Hello, this is Sean Bennett with my tort liability presentation. First, I'm going to define a tort. A tort is a civil wrong for which a remedy may be obtained, usually in the form of damages. In the school context, teachers are liable for acts that may cause injury to a student while under the teacher's supervision. Two major categories of torts typically observed in the education-related cases: intentional torts and negligence. We're going to take a look at 5 different tort cases in the education field. First one being Frame versus Comeau. Okay, in this one, Comeau was a substitute teacher at the time, was giving a test. Casey Frame spoke aloud during the test. Comeau asked him to leave the classroom twice before approaching the desk. As he approached the desk, Frame responded by slowly standing up to face him. Simultaneously, Comeau grabbed Frame by the arm to assist him out of the classroom. The combined actions threw Frame off balance, caused him to stumble backwards down the aisle, where he hit the podium and eventually came to a halt against the blackboard. Frame was then removed from the classroom. Frame filed suit, alleged that Comeau's actions were constituted an assault and battery on him. Frame argued that Comeau attacked him and that his attack was unprovoked. Even if provoked, Frame argued Comeau's actions were excessive in light of the situation. The court found that Comeau committed a battery, although he was justified. Said that Frame's actions were enough to justify being forcefully removed from the class. It's necessary to maintain order and facilitate the learning environment. So they found that it wasn't necessary, and so they sided with Comeau. Some reactive measures that would have occurred. Obviously, in a situation like this, you can probably take a written response from both people involved, kind of see what happened, so it's in writing. What proactive measures would you do to prevent such torts? And for a professional set of ethics, I think it's best that you have it in your guidelines as a teacher that you don't ever touch a student, especially forcefully trying to remove somebody as a teacher. Should be kind of a stair step in that case. If they're being defiant or resisting, then you go to administration. If they don't leave for administration, then you're obviously looking at getting the school officer on campus there if you have one. Okay, I just think it's best for a teacher not to ever come in contact with them in a forceful manner, just to avoid situations like this. Okay, next case is Flanagan versus Canton. In this case, during the school day, the teacher, no students were getting rowdy and out of control during a physical education class. As a result, the teacher stopped the class early, lectured the students on the importance of listening to directions during an activity. After the lecture, the teacher let the students were dismissed and sent into the locker room to change before the next class. While the students were in the locker room, Flanagan, the student, was pushed from behind and caused him to fall into a locker and a bench. Due to the incident, Flanagan sustained several personal injuries, ultimately resulted in an emergency splenectomy. Okay. Although the physical education teacher normally accompanied the youngsters in the locker room, he remained in the gymnasium to speak with another student for not more than 3 to 4 minutes. Okay, based on the events, they sued. Okay, court did recognize that although school has a duty to adequately supervise its student, it does not ensure those students' safety. Okay, so if a freak accident happened, they're not necessarily on the hook for it. Furthermore, the court pointed out that the school is only liable for foreseeable injuries sustained by a student that were caused by inadequate supervision. Okay. In this case, though, they ruled in favor of Flanagan because the students had been misbehaving. The teacher did owe it a greater duty to supervise them on that day. So, reactive measures on this, obviously taking written depositions from everybody involved. Also, we're going to go back and review our rules and put in place more proactive measures, which in my proactive measures, I think it's a good set of professional ethics for teachers, is that we never leave students unattended when they're in our care. They should always be monitored and supervised. You can have what you think are great kids, but they can misbehave just one time. Something like this happens, and you're on the hook and liable for injuries. So I just think it's the proper thing to always have eyes on people, never let them unsupervised. So like locker rooms, hallways, closets, they should always be locked unless monitored. Next case is Jackson versus the Cartwright School District County School System. During this one, Jackson slipped and fell on a ramp by Cartwright Elementary School following her son's baseball game. The facility was actually being used by the Youth Little League team, not a school activity. So Jackson actually filed a suit against both the school district and the Little League organizations. The questions that arose during this was, does the fact that the condition of a ramp was open and obvious preclude liability as a matter of tort law? And then did the Little League have possession of the ramp to the extent that it owed a duty to the appellants? For the first question, it was decided and established that Jackson was well aware of the condition and potential risk associated with using the ramp, but continued to use it anyways. Therefore, there was no duty owed by the school or the Little League team. The court did decide that the Little League was not liable for the fall, even though they were exercising their leasee rights when the fall occurred. School district, however, was held liable because the landlord is liable to third persons for injuries resulting from negligence and the management of common areas retained under their control. So kind of the big issue that comes with this is schools are presented with an additional duty of care and protection for their students beyond the restraints of school hours. This does not relieve the school of liability if an incident occurs if it's being leased out. Schools still maintain the obligation to protect any invitees that step foot on the grounds. Therefore, schools must be extremely cautious when leasing their property or when allowing usage of their property by an outside group. Okay. Proactive measures in this, okay, if you are going to lease out the school, I think should be somebody employed by the school that is there at all times to kind of monitor the situation. I just think that's a kind of a good process to have. Otherwise, limit who you're leasing it out to, or not lease it out at all. Is it really worth a few extra dollars if you're getting paid by them to put yourself at risk for somebody getting hurt? Next case is Gordon versus Oak Park School District. In this one, I think it was multiple children filed suit against the school district claiming that their teachers verbally and physically abused and harassed them. There was 2 failed attempts. After the 2 failed attempts, the students went back and changed their story and said it was because of them being Jewish. Okay. Courts ruled in favor of the school district due to the lack of documentation of deliberate and merciless treatment of the students. Physical abuse could be proven to be no more than corporal punishment for misbehavior, which teachers were authorized to dispense in the absence of parents. And finally, school records reflected concern for the children rather than malice, contradictory to the students' statements. So this one I thought was kind of different. So teachers have to be diligent in documenting disciplinary actions. I think that should be a proactive measure. And the reasons for such to protect themselves and the school from resentful students. Otherwise, circumstantial evidence could indicate that the teacher is wrong in some way, no matter what they do. I think it's always good to document things. I think that should be a common practice. I do think it's kind of unique that just because there wasn't documentation, they got off on this one and they weren't on the hook. So I think that's important. It's an important step to remember there. And our final case is Johnson versus Millard School Board. This one goes in a different direction where you think they wouldn't be at risk. Okay. So what happened here is a first grader at Willa Cather Elementary School was injured while attending Nancy Patton's music class. She taught her class the song and game of London Bridge. The teacher warned the children not to act silly and told them not to yell, scream, or swing their arms too much. After giving these instructions, the teacher did allow the children to play the game on their own. During the game, Johnson was hurt. She swung too hard. They fell back into a bookcase, cutting their head above the right eyebrow. They required 50 stitches to close the cut above the eye. The cut the cut extended to the bone and bited the muscle throughout its length. Suffered blurred vision for a short period of time and continued to have headaches for a period of time. When the accident occurred, the teacher had her back to the class and was writing on the board. Court held that the teacher's instruction to first grade children on how to play a game without direct supervision during at least the early portion of the game was negligent supervision. Okay, we got to know who we're teaching the game to. These are first graders. Probably shouldn't be left alone at any point, especially early, the first time that you've taught them the game. Lesson to learn from this is when your students are engaged in physical activity, must be attentive to them, especially in the first grade, sometimes called standard of care. Their teachers are expected to exercise a level of care according to the age, maturity, experience, and mental capacity of the students and the nature of the learning activities in which they're involved. Okay? So proactive measures, obviously we just always want to be attentive to our students. If they needed to write on the board, that might have been something that we needed to get prepared before class. Reactive measures, obviously you're going to have the first aid to help control the bleeding there, and then write depositions of what happened. Professional ethics is we just always want to be attentive to the students. They come first, especially when they're doing something physically active. I know as a physical education teacher, we don't leave the kids playing a game by themselves in a gym and go off and run and do something. Kids' safety's got to come first. Final screen's list of the references. Thank you for your time. Have a nice day.